following program on Ada Derana 24 is classified for general audience. It is intended for all ages. It contains little or no violence, no strong language, and little or no sexual dialogue or situations.
Tonight, we discuss the intricacies of sovereignty in the Sri Lankan context. What legislature governs sovereignty and how does it translate across the populace of the nation? A very good evening and thank you for joining us on yet another episode of Law, Land and Liberty, where we bring to you key legal concepts and break it down for the layman. Now tonight's topic is a topic that I'm sure that it will interest you very much because it's shrouded in ambiguity, but it's actually enshrined and we know what the specifications are, but we really never look into it as laymen. It never occurs to us what exactly defines it, and that's on sovereignty. The sovereignty of our nation, of course. Now we've had this word thrown around in common sphere quite a lot, but what exactly does it mean in the legislative context? To discuss this, we have someone that I'm sure is most suited for this discussion, and that is attorney at law Rikaz Riffard. So thank you very much for taking the time. You're well versed in this aspect, so I'm pretty sure we can expect quite an insightful breakdown on this topic, specifically how it relates to all of us on an individual level. Well, before we get into the discussion, let me give you a little bit of a breakdown of how exactly we're going to be approaching this topic. First, we'll be getting into the very basics, the historical context and how sovereignty came to be in the country. Next, we'll be talking about the current context and key cases related to sovereignty and what we have seen unfold in current time. And next and finally, we'll be talking about the international standards and also potential reforms and changes that could happen in the legislative aspects related to sovereignty.
Hello, I'm Heshani Kavisha Hirage and I'm a law student at Sri Lanka Law College. My question is based on fundamentals. What is sovereignty and which laws govern it?
Well, without any further ado, let's get right into this very packed discussion. So we have quite a lot to break down as well. But before we overload our audience with a lot of information, I think we should get a bit of a preamble on the historical context when it comes to sovereignty. Could you discuss with us, sir, how exactly the current context of sovereignty came to be, the historical evolution in relation to sovereignty?
Now, before we go into look at the concept of sovereignty, I think it's better if we understand what is sovereignty. Sovereignty means where if we take a society or a particular state, the power to govern that society or the power to govern that state taken all together is what we call as sovereignty or sovereign power. If you look at our history, that is the Sri Lankan history, or even if we look at the world history, in the past, the sovereign power was always centered with one individual, whom we called as the king or the queen. So even if we go a little further back from even in the world context, we know we have had kingdoms, we have had the Roman Dutch law, and we have had the English kingdom. It was always the power was self-centered, or it was with one individual. And if you look at the world, right, in the world, because of this power was with one single individual, or the sovereign power was with one single individual, we have had a lot of issues, a lot of troubles over the past. If I could just bring out one of the key examples is the world wars, is because this power was with one single individual. If you look at Sri Lanka, our context, the history that we can look at in Sri Lanka, we know we have had our kingdoms, which is 2,500 year in our 2,500-year-old history, and we have had kings throughout all of these kingdoms. So at that time also was sovereign power, or the power to control that society was with one individual. So when we see the word, like I said, like the word sovereign power means it's the power to control a society. This power essentially includes few limbs or few arms, that is to create or to govern the society, to govern the people and also to make laws to them, that is the legislative power, and if they don't follow the laws, to punish them, the judicial power. So when we see the concept of sovereignty, even from the past, this one individual called the king, he possessed all that power, that is to control his citizens, to make laws for them, and to punish them when they don't follow it. So all together, this power all together is what we call as sovereign power. So in our history, coming back again to the Sri Lankan history, during the time of the kingdoms, the kings possessed this power. Then we know in our history, after the falling of the Kandyan kingdom, we were for the most of the time we were a colony of the British kingdom, and prior to that we were a colony of the Dutch kingdom, or what we can say is properly that we were controlled, our sea areas or our seashores were controlled by the Dutch. So at the time where this power was with one individual, even in UK it was controlled by a king. So even us, we were controlled. So sovereign power was always in our history has been with one single individual. But during the times of 1800s, or in 1801 to be exact, English, they create the UK Parliament. They think of where to bring in people for the whole controlling opponent of this sovereign power. So even in Sri Lanka, so we were a colony of the English. So in around 1948, we know that we gained independence from UK or from English, but that's the first time we adopt this concept called constitution. In 1948 is the first time we adopt the concept called constitution. But in the 1948 constitution, we did not have the sovereign power. We were still controlled by the British, but we say the constitution that was provided to us is a granted constitution. So, like you asked me, when we were talking about the history of the concept of sovereignty, first I told that sovereignty means what? That is the power to control all of the society, or that entire power to control everybody. So then if we look at the history, then till the time of the Kandyan kingdom, it was one individual. Then after the Kandyan kingdom, we know the proper established system that was inside Sri Lanka was Salisbury Constitution. But before the Salisbury Constitution, we have had few reforms that was brought out by the English governors, like Crewe-Macallum reforms, Colebrook reforms, Donoughmore reforms. But even at those times, sovereignty was with UK or England or English Parliament. Then in 1972, we create our first constitution, or we call it the autochthonous constitution. Why do we call it the autochthonous constitution? Is because we created it in our own soil, the first constitution. So, like I said previously, because of the whole issue of one individual having sovereign power, it has caused so much problem in the world also. The world was shifting on creating democratic society, so what we call as democracy, where rather than one single individual holding all that power, people thought, we will have all that power. We will create a document called the Constitution, and through that document, we will allocate powers to different institutes so that they can act on behalf of us. We elect them, we elect people into it, right? So, even in the 1972 Constitution, which is our the first constitution, first autochthonous constitution, because Salisbury Constitution was a granted constitution. The 1972 Constitution is a constitution which we created in our own soil, but the sovereignty concept in the 1972 Constitution, we created the institute called National State Assembly. In National State Assembly, like I said previously, I said when we take this concept of sovereign power, it includes three limbs. that is we call the governing power, the executive power, the legislative power, and the judiciary power. So essential three powers inside the whole sovereignty concept is these three. So in the 1972 constitution also, when we created the 1972 constitution also, sovereign power was not like now, is not with people. It was not with people. It was with this one institute called the National State Assembly. They had all these three powers together. Then after 1972, 6 years later, we create the present constitution, the 1978 constitution. Even in the 1972 constitution, we gave those three powers. The sovereign power was with National State Assembly, but we say it was not justiciable. Now, what does it mean? It was not justiciable means we can't practically exercise it, or a layman or like a citizen would not be able to bring an action if his sovereign power is violated. But once we created the 1978 constitution, in the 1978 constitution, in its article 3, we said sovereign power is not with one person, it's with people. Sovereign power is with people, and it is, if I am to read exactly how article 3 reads, in the Republic of Sri Lanka, sovereignty is in the people and is inalienable. We cannot transfer it to anybody. It is with us. And sovereignty includes the power of government, fundamental rights, and the franchise. So presently, the whole reason the sovereignty is with the people, the whole reason why it has happened is because the closest the kingdom, or the closest democracy that we saw is the English system. So when we look at our constitution also, we have adopted similar concepts into the sovereignty concept, and also the sovereignty concept now entails, like I said previously, not only the three powers, that is the power to govern, or the executive power, the legislative power, judiciary power. Now there are two more other limbs also, which we will discuss in a bit.
Exactly. That's actually a very good preamble into how exactly sovereignty came to be.
Yeah.
Even though we've had multiple constitutions in the past, sovereignty wasn't truly granted up until it was vested in the people of this country.
Yes.
And that can be considered our truest form of sovereignty.
Yes.
But I believe, so we have to mention about the legal aspects of sovereignty and where it's enshrined specifically inside the constitution, how we get into details on that. And also, you mentioned that there are multiple other limbs now related to sovereignty. I think we should get into that aspect as well specifically.
Now, like I said previously, in the present constitution, the 1978 constitution, sovereignty comes from Article 3. Article 3 is one of the key sections in our constitution. So, Article 3 specifies that sovereignty can be exercised. If you look at the last bit of Article 3, it says like this. In the Republic of Sri Lanka, sovereignty is in the people and is inalienable. Sovereignty includes. So sovereignty includes not only, like I said previously, the power of governance now. It also includes fundamental rights. Now, why does this aspect of fundamental rights is added inside or within the sovereignty concept is a very important question. Now, if I am going to explain that, now, when we look at past, like we were coming from the historical context, when we look at past, in the past, let's say if I said king held the sovereign power. So when he has all the power with him. He has the power to make laws, he has the power to punish them, and he has the power to govern the society or govern the particular state or the country. So practically he might not be able to govern and punish them and do everything on his citizens or on his people. So what he does is he has allocated his power. He has given his officials. If you look at our history or even in our past history or the world history, king couldn't exercise all of his powers alone. So what he did was he kind of allocated his power to his officers or his officials. Now, always when king is allocating this power, right, that power which he gives has a certain limit. if these people or if these officers go aboard or overboard with the powers allocated to them, king could always stop them. Because he is the sovereign power. Now, but with the creation of modern societies, now we are allocating the power to 3 different institutes. Like I said, that is the executive. The executive arm consists of the president and the cabinet. Then the legislature. We give the legislature to power to create statutes, which is for the changing world, for the current context, as is most usable. And we have the judiciary, according to the laws made by the parliament. If anybody doesn't follow these laws, to punish them. So I will come to more detail in a bit. Now, in addition to these 3 limbs, now I said sovereign power includes these 3. If we look at, now we said Article 3 includes the the power of government and fundamental rights. So if you go to Article 4, Article 4 specifies firstly these 3 powers. That is, the legislative power of the people shall be exercised by the parliament. The executive power of the people, including the defence of Sri Lanka, shall be exercised by the president and the republic elected by the people. The judicial power of the people shall be exercised by the parliament through courts. So that is what essentially previously even a sovereign had that power. That is 4A, 4B and 4C. If you look at 4D and 4E, these are the new, like I said, the additions for the sovereign power concept. The 2 are, one is the fundamental rights concept. 4D says the fundamental rights which are by the constitution declared, recognized and shall be respected. Then 4E is franchise. Franchise means just us creating these 3 institutions wouldn't be enough if we did not have the power to elect people into it. Because they are our representatives. They have to be elected. They have to be elected by us. Now, that is the power of franchise. Now, the importance of franchise we understand, because if it was not included within the whole sovereignty concept, any government who would come, they would try to remove that power out of people, and then it will not be a complete sovereignty concept. So also why the fundamental rights aspect is added into it. I think we might have gone in detail about learning about different aspects of fundamental rights, but why fundamental rights is added in the whole sovereignty concept. Like I said, I explained earlier that when the sovereign power was with the king or one single individual, he always had the authority to stop his officers from abusing it on his citizens. Now, the sovereign power now in a democratic society is with people. And we have given by electing institutes or by creating institutes, specifically the executive, right? We elect people to the executive by both the elections that we have. And they are given, the executive is given the power by who? By the parliament as to how they should behave. If executive is given the power by parliament as to how should they behave, what if they abuse that power given to them on the same people who has given them the power to operate? There should be some sort of a mechanism,
checks and balance.
Check and balance, what we call as a check and balance, some sort of a mechanism to stop them.
And that is exactly where sovereignty as a concept is essential to understand for us as individual citizens.
Definitely.
Because that franchise is one of the key areas where we can actually exercise sovereignty. Unfortunately, we have come to time in this segment, but we do have to get further into the specifics as well, and also the current context, of course, with the elections just looming around the corner. We have a lot to discuss on the franchise aspect also. But before we get into any of that, let's go in for a very short commercial break. You're watching Law, Land and Liberty. We'll be right back.
Hello, my name is Sirushan Rupasinghe. I am a law student at Sri Lanka Law College. My question is on the current context. How is the sovereignty protected by the judiciary and legislature?
Welcome back to Law, Land and Liberty. We're in conversation with attorney at law Rikaz Riffard, and we were talking about sovereignty and how exactly sovereignty translates in an individual context as well, and how important sovereignty is for us to understand exactly, and also the historical context. I believe we had quite a bit of a good preamble and a good context now, sir. A foundation has been laid. I believe we unfortunately ran out of time in the previous segment when we were speaking about one of the most important aspects, which is franchise. I think it would be beneficial if we could actually get into specifics on what duties are owed. Now, we spoke about each arm and we understand that they each have their role to play, and specifically when it comes to sovereignty, we'd like to understand how exactly that translates, what duties are owed.
Yes, like I said previously, now Article 4 allocates, or through Article 4 we create different institutes. Now, we understood previously that where fundamental rights is one of the key aspects. So, if in our chapter 3 of the Constitution, we have a chapter which specifies what are the fundamental rights, where if any executive or an administrative authority violates any of these fundamental rights that has been allocated or given to people, through Article 126 of the Constitution, they can petition to the highest court, the apex court of the country, because it's a matter against a citizen to the Supreme Court. Now, that's not the only remedy. Now, so our Constitution talks two remedies when it comes to abuse of executive power. The other remedy is, now actually this power was, like I said previously, where king had the power to stop them. Now, in present context, immediately to stop the executive and administrative authority, someone should be empowered. In a democratic society, someone should be empowered. So, in the Constitution, we have two remedies when an executive or administrative authority violates their power. Now, why? When an executive or an administrative authority violates their power, how it gets connected with the whole sovereignty concept? Now, that's an important question. Now, an executive or an administrative authority is given power through a statute of the parliament. The statute of the parliament, or the parliament, is empowered by the Constitution. So, automatically when the parliament makes a law and gives the power to the particular executive or an administrative authority, and when they violates it, that can be questioned in two courts. One is through exercising the fundamental right jurisdiction through Article 126, and also the writ jurisdiction, which has been empowered by Article 140 of the Constitution. So, that is one of the key things that judiciary does in keeping in order the powers allocated to executive and administrative authorities. Then when we look at what's the duty of the legislature, what's the duty of the legislature in keeping the concept of sovereignty intact. Now, legislature and judiciary, they do a job in hand. In our present Constitution, we don't have what we call as post-legislative enactment review. What does post-legislative enactment review means? Where once an act is passed through the parliament, we cannot question the validity of it. The reason why we can't question the validity of it is because there's only one lawmaking authority in the country where we exercising our sovereign power through Article 4, we have given them the power. So then, does that mean any government who comes to the power, if they hold 2/3 majority of the parliament, right, or let's say if they can come through a referendum, I didn't explain that concept, but if they bring a law which violates the whole sovereignty concept, or for an example, we know that through fundamental rights chapters, there are certain powers given to us. But if they bring a law that violates fundamental rights, or if they bring a law which is goes out of the box of the sovereignty concept, how do we stop it? The only remedy that we have is when it is in its bill stage, that while it's inside the parliament, we can challenge the particular bill through a fundamental rights petition. So that keeps the whole, like you said earlier, the check and balance system. The three arms in the government, they can't be in a strict separation of power. They have to go hand in hand, checking if each limb, if they are going overboard with the powers given to them. That's when exactly the concept of sovereignty will be intact. So if a bill comes to the parliament, and if the particular bill gets challenged in parliament, in Supreme Court through a fundamental right petition, so that is a chance given to every citizen to challenge a bill. Now, previous authorities did not allow always a citizen to bring action, but now we have the whole concept of develop public interest litigation. I think we all have discussed it previously. Because of a public interest litigation action, we can exercise our sovereign power. There is a law coming into the parliament which directly violates with my power. Now, if we look at all recent bills that has come to the parliament, it has always been challenged in the Supreme Court through a fundamental rights petition. So, then once the Supreme Court determination comes, parliament has the duty, if it violates any one of the articles in the constitution, or particularly Article 3. So, how it happens is, if Article 4 A, B, C, D, E is there, so Article 4 D says fundamental rights. So, if a fundamental right is violated, essentially it might violate Article 4D. If Article 4D gets violated, it might essentially violate Article 3 also, because they are entrenched articles. Sovereignty is exercised through Article 4. So when we challenge through a fundamental rights petition a bill that has come inside the parliament, we are technically, or we are challenging our powers that we have given to us. So which means the government is violating the whole sovereignty concept by bringing that particular bill. So all three arms, so I spoke about the duty of the legislature, duty of the judiciary. If you look at the duty of the executive, that executive means essentially the president. Now, we have this wrong notion where we think it's, when we say executive, it's only the president. It's not only the president, it's president and the cabinet. So when we say the cabinet, that means each minister who is holding a position in the cabinet, he's entailed to look after a particular ministry, and that ministry has different departments, and every officer in that particular department is exercising executive powers that we have given to them. So any one of them, so they always have to be within the four corners of the powers that are given to them. If they go out of that box, either through a writ action or either through a fundamental right action, we can challenge the action. So they have a duty when they are exercising their powers. Now we know, like as laymen, when we go in the road, people who has authority, or the person who we see the most is the policeman. So even if a policeman, the policeman who is in duty, he gets his power from the IGP. IGP gets his power from the Minister of. So that link is, or that the power that the policeman exercises while being in the duty is power that we have given. How? Because we created the constitution, and we created three different institutes to exercise the power on behalf of it. So how we do it is, when we look at the whole franchise, we do it through this concept called majoritarianism. What's majoritarianism means? It's always about the majority. Now, we say we scold our politicians, we scold our leaders but the power has been always with us. We are the one who are exercising the voting right. We are the one who are electing people to these offices. So I think even in the future, rather than we blaming different people, we are the one who have because these institutes are acting on behalf of us. So that we should know to elect and send proper people to these institutes.
Exactly. The responsibility essentially, despite seeing a huge chain of command, is basically vested in us, and we have an individual responsibility to ensure that we act upon our sovereignty in an adequate manner. Unfortunately, we have come to time in this segment as well. There's quite a bit more to get into, specifically when it comes to the majoritarianism as well. There is a lot of controversy relating to that, because there are minority groups that may not feel the same as majority, and we can see a lot of conflict in that aspect, specifically in the past few years as well, and also with elections just around the corner. But before we get into any of those specifics and also the current context, I believe we can take a short commercial break. You're watching Law, Land and Liberty. We'll be right back. Stay tuned.
Hello, my name is Gihan Kavindan and I'm a university student. My question is on international standards. How has global powers affected Sri Lankan's sovereignty?
Welcome back to Law, Land and Liberty. We're in our final segment in discussion with attorney at law Rikaz Riffard. So we were talking about sovereignty. So far it's been quite a packed discussion. We've had a lot of context being given to us, specifically because as laymen it's very hard to actually navigate the legal intricacies of sovereignty and the powers vested in us, which we have in turn vested into our government. I think it's important for us, we had to cut it off in the middle, unfortunately, in the previous segment. We can pick right back up. A question posed to you, sir, is how does the concept of sovereignty actually intersect with other legal concepts like democracy and rule of law in Sri Lanka?
It's like this. Now, when you look at the word sovereignty or the concept of sovereignty in different countries or in different jurisdictions in the world, they operate in different ways. Now in our country, sovereignty or sovereign power vests with people. But if you look at most of the Middle East countries, sovereign power does not vest with people. So since sovereign power in Sri Lanka and in most of the democratic countries, what we call as democratic countries or countries which has democracy, is when sovereign power is with people and where they have elected institutes to govern them. That's essentially what a democratic or a democracy means. Now you ask, what is the connection with these other concepts such as separation of powers, independence of judiciary, rule of law? These are all concepts. Now inside or within the sovereignty concept, like I said, there are three institutes. So the way that these three institutes should behave is very essential. If we can draw the powers given to them through a circle, if all these three circles overlap, that means it's essentially creating a dictatorship again. But if these three circles are kept totally in separation, judiciary here, executive here, legislature, then it's very difficult for them to function. So we say the present system that we have is, like we discussed previously, a check and balance system, where one arm look after the other one. So we have examples in the past, like where when the parliament was dissolved before the particular time at the time of the previous, this current president or the previous one, the one before that, we went and challenged it through a fundamental right action. So in most of the instances, judiciary has acted and judiciary has played a role of keeping this balance properly. So how does this get connected with the other concepts? If we take the judiciary, we say this judiciary always have to be independent if the sovereignty concept to work. Why judiciary needs to be independent? Because like I said, the three arms of the governments, the executive, legislature and the judiciary. Now I said the judiciary has to be independent. Now judiciary, previously I told, is given the power through the constitution to see if the executive is within their four corners of the powers, that is by doing the writ, by applying the writ jurisdiction and the fundamental rights. Now in any event, if this judiciary is not independent, right, they are reviewing the executive's decisions without being independent. What's the point? It's like you are judging your own cause. So when the judiciary is independent, then the whole check and balance system comes into place, right? And then automatically the democracy concept comes into place. Now if we look at the other concepts comes around, the parliament supremacy concept. Now through Article 4, when we are allocating the power to each institute, what is this parliament supremacy concept means? Where we have not created any other authority other than the parliament to make laws for us. So parliament is the supreme authority to make laws. Only we have given certain exceptions like to the president to make laws when it comes to emergency regulations through the public securities ordinance. Other than that, so parliament has to be supreme, judiciary have to be independent, executive have to behave within the powers given to them. So if all of these institutes behave within their allocated context or allocated box, if we call it, then we say there is rule of law. Now what is rule of law? Is a concept. It's a concept developed way back. There have been various definitions. Rule of law means, or in simple terms, rule of law means if the society is going according to the rules that have been laid down by the law, that is essentially rule of law. So the present norm that we have established, now previous norms that we had have not worked. Like we were under kings, then we had previous constitutions like the 1972 Salisbury. Now those are not the present norm. The present norm is the present constitution. So according to the present norm, we have the power. How do we exercise the power? We have created institutes. In addition to the three institutes, we have the fundamental rights jurisdiction, and now we have the power of franchise. So taken all of these together, and each of these limbs when they are operating within their powers, that is when we say there is a democratic country, there is rule of law, these arms of the governments are operating in this particular manner. So that's the connection. So it's like it's all the same thing, but when all of it together, only we can see a proper governing country and where people are given the most prominence rather than single individuals.
Right. For one to exist, the other must also exist, and it's completely intertwined. Even though there are specific demarcations. We have quite a bit of an interconnection going on there. I think, unfortunately, since we are fighting against time with this discussion, even though we have quite a lot more to discuss, so I think the international context is very important in this aspect, specifically relating to certain legislatures or treaties that would have been introduced. How does that actually impact our sovereignty?
Now, since we are a sovereign country, I have been saying Parliament is supreme. So which means there can't be any law coming into the country other than Parliament making a law. Now, except for certain exceptions like where we have created the 13th, after 13th Amendment, post 13th Amendment we have created the provincial councils, which I am not going to touch that area. But when we look at the international sphere, just because we sign a treaty, it doesn't become a law in our country. Because why? We have a concept called dualist, monoist countries, and we are a dualist country just like UK. I think we might have inherited because we were a colony of them. And most things of our constitution, even if you look at our parliamentary system, we have a Westminster parliamentary system because of a British influence that we have had. Now, just because we sign a treaty, it doesn't become a law in our country. We have to particularly, specifically pass an act through the parliament. If we look at the ICCPR Act, if you look at the Hague-Visby rules, that is the international rules for shipping law, everything has gone through an act by parliament. Why? Because sovereign power is with us. We have given only one institute to create laws for us. Nobody else can do it. Just because a government decides we are going to sign a treaty, that doesn't become law in our country. So, we are a sovereign state. We exercise our power only within this state and only through the institutes that we have created and the mechanisms that we have created, not through any other means. So, when we are exercising our power, like I said previously, when we are exercising our power, just that we tend to forget very easily, lot of things we tend to forget, and I don't think most of the people in the country doesn't understand the whole concept of sovereignty and that the power is among us. Now, when you go abroad or when you go overseas and when you see a country which don't have such freedom, we have a freedom of expression, not most of the countries has that.
Right, that is exactly an important point, because once sovereignty is absent, we will see exactly how sovereignty has been granting us much more advantage compared to other situations. We're reaching the end of this discussion, sir, but before we end off, I'd like to ask you this very important question. When it comes to the existing aspects of sovereignty, the legal aspects, now, do you see any sort of reforms or implementations, different measures that could be introduced in the future relating to this concept?
Now, essentially, sovereignty means the power is within the people. Now, when I see reforms, I think state institutes, the government institutes, if we can implement more laws to be transparent. Now, you know, after we had a recent amendment, the right to information. Now, that's enhancing the concept of sovereignty. Like that. So, I think it's better if we can bring laws, more acts. If Parliament can bring more acts, to bring more transparency on the decision making process, because they are essentially exercising the powers given by us. Since they are exercising the powers given by us, more transparency, and like I said, in the constitution, to review the decisions made by the executive, we have only two means. So, if we can enhance that, we have more, we don't have to always pressure the Supreme Court or the Court of Appeal, or always sometimes it might be costly to a normal general citizen to file an action, sometimes it might be difficult for them. Maybe to review it, it's part and parcel of the sovereignty concept. That's why the highest two courts in the country has been allocated the power. But when it comes to a reform, if you are suggesting a reform, maybe a more accessible system to normal laymen.
So transparency and accessibility should be
I think is the prioritized. That's what, as a reform, yes. Since it's a concept, we can't per se say these things, particular aspects has to be reformed. But if we can reform this too, more transparency and more accessibility is much more and more key important areas when it comes to the concept of sovereignty.
Right, and importantly, sir, for the viewers watching, is there anything specific that you would expect to carry forward, because as laymen we just got an understanding of sovereignty and how it impacts us really greatly, and how it is vested in us, and it has been this entire time. We've been very dormant in that aspect, in actually taking care of protecting such sovereignties on an individual level. Is there anything specific that you would like to address?
In very specifically, what I want to, and the whole reason why I want to speak of the concept of sovereignty was, as people, as laymen, most of us don't understand the powers given to us. One of the key aspects when it comes to the concept of sovereignty is this our power of franchise. When we are exercising our voting power, and because essentially everything else later relies on, we just think voting is just going and marking a cross and coming back home. But when we exercise the power of voting, that is to vote in a presidential election or a parliamentary election or a referendum, that means essentially that we are electing individuals to act on behalf of us. Our current president is elected by the individuals that we elected to the parliament. So, vote wisely, because you are exercising your powers allocated to you through Article 3 of the Constitution. We have to exercise our power. That power is vested. This is something that we don't appreciate much. And a very important thing that I want to make sure to tell here, to educate students from the ground level about these concepts, and to make them understand what is sovereignty, to include these things in a syllabus, in school syllabuses, and to educate them about our constitution. Exactly,
because of how essential the nature of sovereignty is. I believe our viewers would have a really good understanding now, an insightful understanding on how exactly it impacts us on an individual level, and how we shouldn't be taking it for granted. And it's really an amazing concept that we have been gifted with,
yes.
And we have the right to use it. All right, sir, I think that would be a perfect end off, unfortunately, into our discussion here tonight. I believe our viewers would have taken home quite a lot of information, and hopefully they will vote wiser, and they'll actually consider the concept of sovereignty in a more important sense. Thank you very much.
Thank you so much for having me.
All right, well, sovereignty as a concept may be shrouded in ambiguity to the layman, but it's undeniably the most important aspect of democracy. We leave you tonight with the words of former member of the European Parliament, Marie Le Pen. I believe that sovereignty is the twin sister of democracy. If there's no sovereignty, there's no democracy. That's all we have for you here tonight on Law, Land and Liberty. If you had missed any of today's programs, you can always rewatch by catching us on our YouTube page, youtube.com/OtherDerana English. Thank you very much for watching. Have a good night.